this. There's always this phenomenon in, special education, dealing with the regional center, whatever it is, where it's sort of the way things are done, and sometimes that doesn't conform to what the law actually says or requires. So, as a practical matter, we've all had cases where a parent took the child out of school once a week or twice a week or whatever it was early, and nobody raised any issue about it. And parents got very used to that situation. And when it was brought to their attention that actually you can't miss large amounts of school unless it's an excused absence or the IEP team agrees to it, people were sort of shocked. Like, what do you mean I can't take my kid out of school? So I think where we start is this. Compulsory education is not something that begins until age 6 in California. Check your law in your own state. But when you're under 6, I don't think there's any real basis for them saying that you have to, be in school all the hours that your IEP or the schedule provides for, because your attendance isn't compulsory. On the other hand, they might say, well, you entered into an agreement with us about this IEP and now you're not letting us implement it properly. But theoretically, attendance doesn't become compulsory till you're 6. Once you're 6 and your parents need to start taking you out of school for extra therapy sessions, clinics, or other things that are non-medical in nature, what you have to look at is the state law on what are considered excused absences, right? So I'm just going to read you the list really quickly, mindful of the fact that Shannon told me not to rattle paper, so I'm trying not to rattle. Okay. It says, you can be legally excused from school when the absence is for the following reasons. Due to his/her illness. Well, that's interesting. I don't think it means because you have an ongoing condition called autism, so you need to be pulled out of school. But that argument did occur to me. Due to a quarantine under the direction of a city or county health officer. So, maybe if everybody had chickenpox or something. Medical, okay, so listen to this. Medical, anytime you have a doctor's permission. Dental, anytime you have a dentist's permission. Optometric, eye doctor, or chiropractic appointments. So that's very specific and does not provide for other types of appointments. 4 is a funeral service. 5 is jury duty. So that'd be a much older kid. 6, illness or medical appointment during school hours of a child of whom the student is the custodial parent. That has no bearing on our situation. That means if you're a 17-year-old father of a 2-year-old and he needs to go to the doctor, dad can get out of school to take him to the doctor. Exclusion for failure to present evidence of immunizations. Well, I don't think we want to go down that road today, Shannon.
No, not today. Another day, but not today.
Yeah. Okay, exclusion because a student is a carrier of a contagious disease or not immunized from a contagious disease. Students grades 7 to 12 who leave school with the prior approval of the principal or his designee to obtain confidential medical services. The student is to return a copy of the medical professional's appointment verification forms. So see, you have to have a doctor's note for that, even if the principal says it's okay. And then there's kind of a catch-all category. Upon written request of the parent or guardian and prior approval of the principal or his or her designee and pursuant to board policy, a student's absence may be excused for justifiable personal reasons, including but not limited to an appearance in court, attendance at a funeral service, observance of a holiday, when pupil's absence has been requested in writing by parent or guardian and approved by the principal or designated representative. There's also attendance at an employment conference. I skipped that. I missed that. Okay. 11, I'm not even going to read you because it's ridiculous. It doesn't apply to any of our kids. And that's most of it, okay? I mean, there's a little tiny bit more in it. I'm not going to waste our time on that. So then you get into the question of, okay, you've got state law that specifies what constitutes an excused absence, and then you've got board policies that, in theory, interpret that law and may add some stuff on. So, for example, if you all want, you could go look at I'm looking at it now, the LAUSD board policy on absence. and it adds it basically is like 48205 of the Education Code, except for that it adds a few things. For example, one of the excused absences is if you want to take your daughter to work day or something. I saw that in there. But it goes on to say, if you aren't absent for any of these reasons, you're truant. And that's where we need to talk a little bit more.
But hold on one second, Bonnie. Correct me if I'm wrong, because now with insurance the way it is, in order to get ABA, you have to have a prescription from a doctor for ABA. Would that not constitute that prescription saying that you have to get ABA, which then covers however many hours of ABA? Within that ABA, you have clinics and appointments. Wouldn't that just cover everything that you would have to do for ABA and make that a doctor's excuse?
It's a good question. It's an interesting question. I don't know if anybody's tried it. It's not going to be covered in the case law, although I didn't get a chance to look at the case law. But I would want something from the doctor that was much more descriptive than just the prescription. I would want the prescription and an explanation of what the treatment is going to look like and the frequency at which the child is going to be out, because otherwise you're going to be potentially truant. And people think truancy just means if you miss the whole day of school. But truancy can also be if you miss partial days of school. And if the district wants to play hardball with you, what they can do is they can initiate what's called a SARB hearing through the district attorney's office, and they can actually prosecute, the district attorney's office can actually initiate a case and prosecute the parents for not bringing the kid to school.
See, but this makes me angry, Bonnie. I'll be honest with you. This makes me angry because a lot of times, listen, I'm an ex-teacher, and I think school is important. And I think, having kids in the seats is really, really important. But I also, like you, have had a child go through an intensive behavioral intervention, and what he got and what we learned in the clinics was far and above anything that happened at school. Well, it made him capable of going to school.
I understand that it is going to be disturbing and unpalatable to parents to be told what they can and can't do in the medical realm. And I think the way you get around it is this. You get the doctor to outline what the treatment will look like. And the analogy would be like, well, if you had cancer, if you were a kid and you had cancer, and then after your cancer you had to have chemotherapy, if the district took the position that you could only have the cancer surgery but not the ongoing follow-up with the chemotherapy, that would be wrong. And I think if you bring that to the IEP team and you're very specific about what you need to do, I think that it's going to be hard for the IEP team to refuse the doctor's indication. They might squawk about time. Can't you do it later? Can't you do this? Can't you do that? But ultimately, I would think with the doctor's documentation, they would have to back down. But the point I wanted to make to your listeners is the state of the art now is you cannot take your kid out of school without a justification that's recognized in the education code or the board policy. So it's amazing how many people I've known that the school has just acquiesced.
Okay. I think they should. I think they should acquiesce. So maybe what we're saying here then, what I'm hearing, Bonnie, is if you see that they're giving you difficulties about it, head it off at the pass, call an IEP meeting, come in with your argument about, look, if this were another kind of thing, you would allow this. And so please agree to it so that you don't wait to get a truant, get the IEP team to agree to it so that it's a non-issue moving forward.
Yeah, and I mean, think about it this way. Where you're going with this IEP team request is one of two places. Either it gets resolved at the IEP level and it gets written into the IEP, or don't shoot me, you're headed for due process and you're going to say it's a denial of FAPE, or you're going to characterize the argument however you would best characterize it, for a student not to be allowed to get his in-home therapy. It's really going to be very hard for a hearing officer to say something that's medically necessary, can't make school yield. Because if you think about it, you have kids that are on home hospital, right? And they don't go to school at all. And they have like 2 hours of instruction a day. Maybe I should have looked at the criteria for home hospital, but there are instances in which students are not truant and they're not in school. So this would not be the only one.
Absolutely.
But anyway,
well, I think you're right though. I think it would be very hard for the school to make a case and be willing to go to due process and not acquiesce. I think you're absolutely right.